Negligence relies on proof of causation. Traditional causation rules require that the defendant's act more likely than not caused the plaintiff's injury. Medical malpractice claimants, whose chances of recovery have been reduced by a doctor's negligent failure to diagnose their condition, have pushed courts to adopt the loss of chance doctrine. Loss of chance allows a claimant to prove the negligent act resulted in a possibility of harm rather than a probability. The loss of chance doctrine recognizes that a reduced chance of a favorable medical outcome is itself a compensable injury. In Smith v. Parrott, the court mulls adopting the doctrine. Stephen Smith awoke to discover that he had diminished control over his left foot. That afternoon, he saw family practitioner Thomas Parrott. Parrott believed Smith suffered from foot drop, a neurological condition that impairs or entirely cuts off the motor functions of the foot. Parrott referred him to a neurosurgeon. 11 days passed before the neurosurgeon's consult. The neurosurgeon informed Smith that the foot drop had become permanent. Smith sued Parrott for medical malpractice. Smith claimed that his condition became permanent because Parrott failed to secure an immediate neurological examination. Deposition testimony suggested that Parrott's negligence wasn't the likely cause of Smith's paralysis. The neurosurgeon who treated Smith believed his foot drop became irreversible 2 to 3 weeks before the examination. And crucially, Smith's expert testified that because Smith had undergone previous back surgeries, an earlier neurological consult would have given Smith a less than 50% chance of recovering function. With Smith's chances of recovery below 50%, the trial court reasoned that Parrott's negligence wasn't a but-for cause of Smith's injury. The trial court also rejected liability based on the loss of chance doctrine. Smith appealed to the Vermont Supreme Court.